My name is Todd Holmes. I'm a partner in the litigation practice, and with me is Mike O'Brien, who is in charge of our litigation support lab. Mike has led the group since 2006. He supervises a total of 4 people in the lab that do full-time electronic discovery work for our cases and our clients. Collectively, his group has over 50 years of experience in electronic discovery, which is noteworthy if you remember that the federal rules were amended to address electronic discovery only 10 years ago in 2006. Today we're going to talk to you about some of the ways that you can manage and control your electronic discovery costs, because any of you with any significant experience in litigation know that these days that is a major driver in the cost of litigation. We're going to talk about three main areas here before we all head up to Wrigley. The first is pre-litigation. So when you're either reasonably anticipating litigation or there's some looming threat of litigation, we've identified some key areas that you can take steps then to reduce your cost and the risk for your organizations. Next is once everything is kicked off and you're actually in litigation, Mike and I are going to talk about the different options that are available to you if you don't have a native or organic group in your organization to handle your electronic discovery needs. Then finally, we're going to talk about e-discovery in general, things that you can do proactively today if you're not anticipating any litigation, hopefully, or if you do, you know who to talk to. But just things that you can begin to do at the organizational level that will have significant cost savings benefits for you down the road. So with that, I'm going to turn it over to Mike, who's going to talk about some of the, in pre-litigation, you're anticipating some problems or a potential dispute, and some areas that you can take some decisions to reduce cost and risk.
Thank you. Good afternoon, everyone. We really want to focus on things that you can do. Some of these are technology solutions, but some of them are just things that you can do and go back and implement tomorrow if you really wanted to. So we're going to go over different ways that you can reduce the risk and cost of litigation. One of the main things you want to do, and it's good to do this prior to any litigation, is to really map out all your data sources. In the event that you have to go collect your data, if you don't know where it's at, you could have hundreds of servers, you can have thousands of servers. If you don't know what's on each server, what data sources have potentially responsive information, it's going to be very difficult to do that under when litigation is already ensued. The first thing you want to do is really map out all your data sources. And, it's easy to go out there and identify your email servers, your network file shares, your home directories and personal directories, but it's important that you also take into consideration collaboration systems. It could be a document management system where you store project data. It could be ShareFile or SharePoint, which is a very popular Microsoft platform that a lot of companies use these days. Well, people can store documents on there. Legacy systems. These are old systems that may not be updated anymore. The people that create it may not even be around. But you find out in a lot of companies, you're going to find somewhere inside the accounting department, there's one application and been using for 10 years. It still works, but nobody really knows about it. The network team doesn't even know it's there. Your IT folks don't know it's there, but it's a source of data. And so identifying that prior to litigation is important. Third-party storage. These days, everyone I'm sure has heard about Dropbox, Box.com. People are storing documents off your networks. But your major technology partners, you got Apple, Google, Microsoft, Amazon, providing you storage in the cloud. And a lot of companies are taking advantage of this for whatever reasons, but you also have employees taking advantage of it, and you may not know that. So it's important to identify that because you're going to have to be able to get that data out when needed. You got archive systems, but even backup systems are very important. A lot of times you can consider those not readily accessible, but you need to determine based on every one of your data sources what the backup schedule is, how long you keep those backup tapes before they're overwritten, and what you actually have on hand. In the event that you have a dispute that goes back 10 years, the actual active data may be gone, and the only source of data may exist on backup tapes, and you still may have those in your possession. You need to preserve those, and you may even need to produce from them. So it's important to identify what you have and make sure that you can account for those. Next thing it is for all those data sources, who's the business person or business group that owns that data? So in the event that there's a dispute, you know the key contact to go to and get a quick understanding if the data from that source is potentially responsive to your dispute. The next is, and I think even more important than that, is the IT technician. Who's responsible for that? You know, like email, you got typically an email exchange administrator. Well, that email system, you may have auto-delete set up on accounts so that after 30 days, anything in deleted items is purged. Well, if that person, the IT person, doesn't know that there's a litigation hold put in place, there is potentially responsive data that is going to continue to be purged from your system. So it's critical that not only the key individuals that are involved in the dispute, the key custodians, you have to get in front of the IT folks and make sure that data, if it is being automatically purged, that is suspended. And a lot of folks forget to include the IT in that process. Some of the things that we consider best practices, years ago, companies were told to keep their backup tapes for 7 years. Well, backup tapes are for disaster recovery. They're typically not for archival and restoral. Well, who told you to do that? The backup tape manufacturers. They want to keep selling you these before you reused them. So sure enough, we go into clients years ago, and they had 7 years' worth of backup tapes. Well, those can potentially be pulled up in discovery. What we look at is if your email system crashes today, you're not going to go to a backup tape from 2 years ago and restore it. That's worthless to you. You're going to go to last night's backup. You're going to restore the email system. Hopefully everything comes up and you're back up and running. So you really should start looking at your backup tape policy, how long you're keeping them and why. If you're keeping them for long periods of time, they can get pulled into a dispute. And they're costly to get data off of if you have to. The last one is convert your legacy data. A lot of times people convert an old platform to a new platform, but the IT folks have a tendency to keep that old data sitting there. Why? Well, just in case something goes wrong, they always can resort back to that, or maybe even the data is not migrated over. Everyone forgets that it's sitting there. Well, that data may be difficult to get at, but you still have to account for it in a dispute. And Todd's going to go over right now, a company had legacy data, and things that went wrong.
Sure. One of the things that we're going to do is scatter some case law in here that can kind of serve as some practical pointers for you, and each one of them has a key point at the end that you're going to see is kind of what I call the whammy moment. But in this case, it's a case out of the Western District of Washington. It's from as old as 2009, which in the e-discovery world is pretty, that's a vintage fine wine for us. But Starbucks had a dispute with ADT, and ADT came in the 26F conference and thereafter and said, we're still using this old legacy system, and it's very cumbersome for us to draw email off of our servers. And at first, they gave an estimate that it would take them 2 years and cost about $8,000. And then at the next hearing, a few weeks later, they came in and said, wait a minute, sorry, that was wrong. It's actually going to take us 4 years and over $800,000. The district court was very unimpressed with that and found it very, very incredible. And in the end, the district court said, despite what you're telling me about your systems, you have made the decision to maintain this old legacy system, and you, ADT, have made the decision that now kind of encumbers your adversary in litigation. And I'm not going to disadvantage Starbucks, the plaintiff, because you, ADT, a sophisticated company that ironically is in high-tech security applications, chose not to migrate your email over to a modern-day server or a functional archive system. The court had ruled that even if the information wasn't reasonably accessible, which is kind of a standard bearer in a lot of these cases, that ADT would still bear the burden because good cause existed to order the production instead of to prejudice the plaintiff and not order any production of the emails at issue. So this is a teaching moment that we often use. We do a lot of work for middle market companies, some of which are private equity owned, and we'll sit in those meetings where they're talking about decisions whether to upgrade the systems of those middle market companies. And obviously there's a lot of emphasis on what type of budgetary aspects do you have to consider in implementing this decision, because the equipment costs money, obviously there's capital expenditures, it's a distraction for the staff of the company to migrate over, and it can really begin to eat into the profitability of the company. One thing that we'll quickly often point out is what happens if you don't migrate over? And we obviously don't have a dog in the fight. We don't sell the new equipment. But our concern is if you don't migrate over to a new reasonable system where you can go back and identify some custodians and pull their data back to search for responsive information, to go into court and play the ADT card where, Judge, it's going to take us 4 years and cost $800,000, you're going to find yourself on the receiving end of an $800,000 bill. And as we'll see later, I'll do a little bit of foreshadowing, you can even find yourself in a situation where you complain that it's going to take 4 years and $800,000, where you're going to turn over your raw data to your opponent's counsel because they can come in and say that they can do it cheaper in a hell of a lot less time. So if you're beginning to make those decisions, and we all face those decisions, one of our clients asked us to consider a new security platform for some of their emails because they were concerned that hackers, instead of going straight towards them, would come through us and try to get their data because we store a heck of a lot of data upstairs of theirs. And they asked us to do an upgrade, and the partner sat down, and it was going to be a capital expenditure of over $1 million. Well, that gets a lot of people's eyebrows raised. But if you're not making those decisions, you're going to find yourself eventually on the receiving end where the court's going to order you to do it, and you're going to pay the money anyway just to sort through your old system.
One thing that we try and preach to our clients is keep the data centralized, keep it on your networks. It's much easier to control at that point. You don't want people copying it down to the local computers. You got 20, 30 different people have data working on the same project, have it all on their local computers, have it on external thumb drives, even taking it home. So it's important that from even a cost standpoint, that if it's all centralized, it's all on your network, you have one place to go, one place to collect, and one copy of each file. Well, if it's on 20, 30 different computers, you're going to collect the network files are there, but then you have to go and take on the cost and the burden of collecting it then from 20 additional computers, and it's just going to be that more expensive into litigation. The next thing, when a litigation hold is put in place, you greatly reduce the risk of spoliation if that data is not sitting on your network. We can easily lock down any repository within a matter of minutes and preserve that data. We can export it out from a network standpoint if we want to very easily. But if the data is on 20 different computers, we have no control over that data. You're relying now on your employees to preserve that data, and we find out a lot of times that employees don't even know what a litigation hold means. Todd was showing you a little bit, someone got litigation hold and no idea what the responsibilities were for it, so they continue to delete data. The other thing, if it's on the network, we know where it's at. We're not going to miss it. You point us to it. It's right there. We got the data. We collect it. If it's on 20 different computers, you have to go interview those employees, find out where they're storing the data. And you'll find out that something that you don't want is that it's all over the place, which we typically find. And so likelihood of missing data sources is greatly reduced if the data is sitting on your network. And some easy things to do, most companies have them. Have some shared network drives, department drives, project drives, where people can collaborate and store all their documents together. Everyone knows where it's at. They can get at the data. They don't have to put it locally on their computer. Data archives. The reason why you hear a lot about archives is because, like an Exchange server for your email, that's very expensive storage on the email platform itself. And so because there's a large volume of email, they want to get that data off, and so what they do is put on email archive system. Much cheaper storage, you still have access to it through Outlook, and so archive systems are cheaper ways to get access to your data when you still need it on your network. Prevents people from taking it off the network. Another one is enterprise text messaging. If you need it for business purposes, strongly recommend that you get an enterprise type text messaging that's controlled by your IT folks. You can log it, you can track it, you can preserve it, and it's easy to produce when needed. You don't want to have to rely on 10, 15 people using their own phones, have their own text messaging apps. There's all kinds of different ways to text these days, and then having to rely on them preserving that. And even if they do, it's very costly to get that stuff off the phones and then produce it. So as Todd will kind of go into now, some issues with people that actually had issues dealing with text messaging.
And I don't know, you guys are probably a lot like me. My typical morning, if I'm not in court or in a deposition or something, will start like this. I'll be on the phone with a client. Another client will call in. I'll think, all right, they'll go to voicemail, and I'll call them back in a couple minutes. Within 30 seconds, my cell phone rings. It's the same client, thinking, all right, they're not instantaneously available there. I'm going to try another spot. Within 30 minutes or 30 seconds of that voicemail being left on my cell phone, I then see an email that says something usually along the lines of, "Call me urgent!" exclamation point. And after that, I'll get a text message that says the same thing. To me, that's irritating as hell, because if you just leave a voicemail in one place, I'll call you back. But what's even worse is I think clients, especially younger clients that we're beginning to see, are in much more of a mode where they're willing to have substantive conversations through text messages. And that's really an awful system. There's less security involved than in an encrypted email transmission. And as Mike has pointed out, if something goes to litigation, and if you have a control group of 3 or 4 people in the C-suite, and they're all of this generation where they're focused on texting to rapidly communicate with each other, you just increased your e-discovery budget dramatically. Because for us to take those, to give an example, we could go upstairs right now and live stream data out of one of maybe 60 portfolio companies of various private equity firms. Right now, we'd be able to say which custodians, what part of their drive, what are the email parameters in terms of temporal limitations, in various folders for a particular issue, et cetera. And Mike could have the data in our systems that evening to begin to process it. If we have to go into a text message, we have to have everybody come in with their phones. We have to send it to an outside vendor who has a forensic tool that can lift those text messages off. They don't get to use their phone for usually at least 24 hours, which drives people batty. It's almost as if you're taking away their life for 24 hours. Then we get the phone back, we get the data back. It's harder to get that data into our forensic review tool, but we can do it, and you've just run up the costs. But another case that will probably make this even more ominous for you than just me saying don't text message about anything substantive is this Nuvasiv versus Madsen medical case. It's Southern District of California. It's pretty recent. It's from last summer. There, the defendants contended that text messages could evidence secret coordination between the plaintiff and some former employees of the defendant. So this would be a case right up Rachel and Dan's alley. And then as the court began to process this is what it learned. One employee, after he'd received a litigation hold, wiped his phone and gave it to his son. So those text messages are gone. A second employee turned their phone in almost 2 years after the litigation hold was put in place, but texts from the relevant time period were gone. So they had texts prior to the relevant time period, texts after, and that's a little bit suspicious. A third employee had his phone wiped twice before turning it in. And let me just ask this, raise your hand if you've ever had your phone wiped. Okay, that's 2 more than I thought it would be. But a little suspicious given the timing and the litigation hold. The fourth employee was probably one of the most honest, and he stated, yeah, I think I may have deleted some messages that were relevant to the issue before I actually turned in my phone. The court went apoplectic and said the text messages are clearly part of ESI. If you receive any modern day document request from any counsel worth their weight, it's going to include it within the definition of document, and said the company was at fault for not enforcing compliance with its litigation hold. What's worse is, then here comes the whammy moment, the adverse inference instruction was issued, and it was deemed appropriate in light of all the shenanigans with the text messages. An adverse inference, for any of us in the room that regularly try cases, is an invitation for a jury to have very short deliberations. It basically says they don't have to, but they may assume that anything was in the deleted data. And I've been on the receiving end of those where clients haven't complied with litigation holds. And let me tell you, it's a very ominous feeling to get ready to step in front of that jury. And I believe probably 9 times out of 10, those cases settle on very unfavorable terms to the person that's got the instruction being issued against them.
This next thing, which ties in closely with keeping the data on your network, these days, in order to do that, you need to give remote access to your employees so they can work, as you want them to, 24/7 on weekends, on vacations. So you need to somehow give them remote access to your network. And if you do that, that eliminates the need for them to work from their home PC, which means there's not going to be your corporate data sitting on their PC, so you don't have to worry about collecting that data source. Eliminates the need for personal email. A lot of people are going to send stuff to a personal email account so they can get access to it from a browser, from any computer. Now you don't have to worry about collecting their personal email. Eliminates the need to put stuff on thumb drives, removable storage devices. There's a couple things about that. Is one, you don't have to worry about accounting for that device. But the other things is 9 times out of 10, those devices are unsecured. They're not encrypted. So if you have your employees copying data on an external device so they can go home, go on vacation, so they can work remotely, They lose that thumb drive, which happens all the time. Now you're at data that you have corporate data, confidential data out there in someone else's possession. So it's really critical these days that you give your employees access to remote in, and that keeps the data where it should be. It should be on your networks. So easy solutions. We've been using Citrix for about 12 years here, 13 years at the firm. Anyone that has a web browser can remote into our network systems and get access to everything they have just like they're in the office. Virtual network connection, or VNC. Same thing, you're connecting directly to another computer within your company that now has access to the stuff on your network so they can perform their work. Even mobile devices. You got access typically to your email. Well, we can easily shut down that access to your email in about 15 seconds, have the network guys, so when you open it up, we can actually get rid of that access for you. Same thing with other apps that you can use, enterprise apps. You can get the data on the mobile device, which needs to be protected. The device is typically encrypted, but we can remove access to that data source in a matter of minutes. So having stuff on your mobile device, once again, allows you to work remotely and not have to worry about having data in multiple sources that you need to collect from. The big thing in litigation is everyone wants the email. No matter what you do, if you create documents, they may be on your local computer, they may be on your network. Well, someone's going to do something with that document. They're going to email it to someone typically. So what everyone's looking for, obviously, is let's get a hold of everyone's email. Once again, the volume of email these days has caused the cost of litigation and e-discovery to skyrocket. And ways that you can control that is, one, not allowing individuals to create archives or local creation of PSTs. And what that is, you're actually taking the email. What's going to happen is usually, once again, your Exchange server, your email server will start to bog down if there's a lot of email on it. Your network administrator is going to be on you about deleting email. Well, a lot of them, years ago and even today say, can you export out everything from last year, put it on a PST on your local computer? End user says, yeah, I still have access to it. I can get on, from my local PC, I go open up Outlook, my email's there. They don't care. Well, you start to lose track of that there's 15 years worth of email sitting on someone's local computer. Nobody cares about it because they're managing and auditing what's on your servers. So what you should do is really block access to creating PSTs on local computers. OSTs, same thing with laptops. OST is a little different. An OST on a laptop synchronize whenever you connect back to your network with the email that's sitting on your network. So in theory, I don't ever have to worry about what's in the OST because it's synchronized with the network. Same things in both places. Well, what happens is, just like with anything, computers, OSTs have problems at times syncing with the network. So what a help desk person will do is create another OST for you, resyncs back up, you're good to go. Well, the issue is now you have orphaned OSTs sitting on your computer that are no longer talking with the network. So you're deleting email, think stuff is gone. 2 years later, you turn in your laptop, some key emails are sitting in that orphaned OST that are now recoverable. You thought they were long gone, but they're still sitting on your laptop. So once again, we recommend that you don't create those OSTs. You can get connection pretty easy these days. Work when you're connected directly with your network. Business-related emails. Basically, your email store is not a repository. It's not, typically what we call an approved records management repository. That's not where you're going to retain documents that you have to for records management purposes. So put them in the true repository, which would be some sort of document management system, ShareFile, records management system. Don't keep them in your email system. We see all the time, because we collect email quite often from our clients, and you wouldn't believe it, but we've seen over 120,000 emails in someone's deleted items folder. Well, at that point, we're now collecting those documents. There's no organization to your deleted items folder. We have to collect all those, we have to search them all, and the attorneys are going to review them. Well, obviously if they're in your deleted folder, you wanted them deleted, but Microsoft was smart enough to say, hey, you probably don't know what you really want, so we're going to put them in delete them items folder. Well, now they're going to sit there until you actively delete it. Well, you can put on the network side, you can turn it on and put policies on that after 7 days, 30 days, whatever you deem, that you're going to automatically purge stuff from that deleted items folder. So now you're not going to run into this issue of 120,000 emails in someone's deleted items that are now part of Discovery. People take it a step further. Your sent items. I've seen the same thing. 150,000 emails in the sent items folder. Nobody goes to manage your sent items. Well, put an auto delete on that. You're going to greatly reduce the amount of documents that are in Discovery. And we've taken a step further here at Freeborn. It's on our inbox. Anything over 6 months, if you don't actively folder that, so anything you put in a folder, now it's put by project, by client, by matter, by issue, we can easily get that in the event of Discovery. So after 6 months, something's unfolded in your inbox, that meant you didn't care about it, and it's automatically deleted. So, in the event that, we have to produce stuff, it's very easy now. I can just grab 6 months of the inbox because it's not foldered. I can go back to, 3 months of the sent items, not that much, and then pick out the folder or folders that they said, here's stuff potentially related to that matter. Very easy, and it'll reduce our volume of email that we need to collect by 80, 85, 90%. So we highly recommend, that you put email controls in. And a lot of people didn't like it at first, but we've had it in for several years now, and it helps control our email and also our risk. There's a lot of email out there you don't want, or you don't want to see come up in litigation. So this is a great way to help that out. Once again, solutions to it, email archive. So your Exchange administrator is not getting on you about, hey, get your email off the server, put it in PSTs. Well, no need for it because we can put it on a cheap archive storage. It's much cheaper. Document management systems, once again, a place to put your records, business records that you need to keep. Voicemail, once again, it's probably rarely considered in litigation. Probably the reason why is your typical phone system. I don't know about most people, but usually it's 7, 10, 14 days, and then your voicemail is gone. Well, once you find out about litigation, usually there's nothing in voicemail that you're going to need to worry about. Well, with new technology, what's called unified messaging, you got technology companies that are pushing to put your voicemail come as an email attachment in your email. Say, great, it's convenient, you have it in your email, you click on it and listen to it. But the problem with that is that one, you've heard about the thousands, hundreds of thousands of emails sitting in folders. Well, now you add all this voicemail to it, your storage costs on your email servers are going to skyrocket. So if you thought your IT folks were upset about all the email you have, just wait now, start putting all your voicemail in there. They're not going to be too happy. But now what do you do in litigation? These voicemail files, WAV files, they're not searchable. You can convert it. It's costly to convert it to searchable text. But now you have to account for this stuff. So we highly recommend that you don't do this. But you do have a lot of technology companies say, hey, great new feature, go ahead and implement it. We just upgrade our phone system, and that's the first thing we tell them, take that off the table because we don't want it.
We have one client where they're regularly a litigant, mostly on the plaintiff's side. Those are the worst damn documents ever. You just listen to it and your heart just drops, because if you think people are uninhibited about emails, they think leaving a voicemail for the CEO or for the CFO that everything's fine and it's going to be gone. And I'll tell you what, when you prepare for a jury trial and that person's voice is going to be, in effect live in front of the jurors, it's an awful feeling. They remember that more than anything.
And then, the last thing in terms of, the last steps you can take, prior to litigation is implementing some sort of records management system. A lot of your businesses, you need to retain documents based on regulatory, business, or legal needs. So you're required to keep these. If you had some sort of records management system, you can start to determine what is a document that needs to be retained or a record that needs to be retained, and then start attaching retention periods. Based on a class. It could be HR, accounting, any type of business documents, financial that you're required to keep. And then you say, HR records, we're required to keep, these employee files for 10 years after they leave, whatever the case is. Then the thing that you really should do is at the end of that retention period, make sure you are destroying that stuff. Because, in the event of litigation, you could have said, 2 years, we could have got rid of that. Hey, let's do it now, or you can't. The minute that you have a litigation hold in place, you need to suspend, any destruction, even if your policy said you could. And, that's a critical piece. We have, some clients that say, hey, we don't have to worry about this because we don't destroy anything. And they're all great. Spoliation, we don't have to worry about it. Yeah, but the cost of litigation is extremely high when there's hundreds of thousands of documents that need to be searched, collected, searched, and reviewed. So yes, you reduce your spoliation risks, you may eliminate them, but on the other hand, the cost, explodes on you. So, we always preach, after a retention policy, remember, destroy these documents if you no longer need them. Otherwise, they're going to be pulled back in. And, Todd will go over another case here.
So the next case that we want to talk about is about data retention or document retention policies. It's Cruz versus Avco. And there, the defendant went in and they said, well, we haven't produced certain documents because we destroyed them in compliance with our own data retention policy. And the court said that's great, but you're supposed to suspend compliance with that policy as soon as you reasonably anticipate litigation. There are two other areas where you have to suspend compliance with such a policy. One is if you have a contractual obligation to produce data to someone, or two, in certain instances, your company might be subject to some kind of statutory obligation to do so. But there, it was a pretty straightforward issue, but the ultimate death sentence was issued by the court. The trial court said, no, you had a document retention policy, but you didn't suspend it once you reasonably anticipated the litigation. They actually continued to disregard that, and there was a motion for sanctions brought. They were found to have violated the court order. The court imposed the most severe sanctions that any of us can imagine. They deemed all of the allegations against the defendant admitted, makes for a quicker trial, and deemed that all of the defendant's defenses were stricken. For some reason, one plaintiff settled before the punitive phase, so they settled cheap. One plaintiff kind of continued on and hit the bell for $17 million. So I would encourage you, if you don't have a document and data retention policy, get one or work with someone like us to help you create one that's fair and reasonable given what your company does. Implement it, find a way to audit compliance with it, and if you use an outside auditor, make sure that there's some kind of open kimono flow of information between the outside auditor and the people that are actually making decisions about its compliance. The next topic we're going to talk about is, all right, we all realize that e-discovery is a nut and bolt part of litigation. It's not going to go away. Alex talked about how some of the rules are changing in terms of how the federal courts are dealing with it, but it's like computers. That old anachronistic partner that's upstairs that say they're just a fad and they're waiting for computers to go away. That's just not going to happen. Likewise, e-discovery is here to stay. And there are three basic models out in the marketplace that can help companies deal with their e-discovery obligations. Mike is going to go through his analysis of those three, and then we're going to talk about a case study that we think kind of helps demonstrate to us what we believe is the best model.
When looking for a partner, be it a vendor or law firm, to help you with your preservation requirements, your collection, processing, and producing, it's just important to make sure that they have the expertise in-house to handle it. You got people that change over a lot of time at vendors, at law firms, whatever the case is. You want to make sure that the people you have you can count on. They're there all the time. You're not going to see a different person, hear from a different person, through your cases and all that, and that you're confident they know what they're doing. In terms of vendor pricing models and law firm pricing models, there's really three that we see out there. The vendor pricing model is based off per units. Typically, they're going to charge per gig, per document, or per page. And just an example of what per page would be is if you're going to be producing documents, they convert them to TIFF images, you're going to get a per document conversion fee. You could get, if they got image-based documents that aren't searchable, they're going to charge you to OCR those documents on a per page basis, or even endorse them for production. They're all getting creative on how they're bundling these fees, but typically they're in some form of per unit charge. Your biggest costs are going to be with the processing, which is usually charged per gigabyte, and also for your hosting, which is going to be charged per gig. Typically, if it's a large case, your largest fees are always going to be in the hosting fees. The data is sitting on their networks, making it available to you. Law firms, there's a lot of law firms out there that do their own e-discovery, but they take the similar model as a vendor. Usually they're going to be a few dollars cheaper. They say that we're cheaper than a vendor, but they're also out there to make a profit with the same model. So you're going to see really the exact same model out there. And then the third one is what we like to term client focus pricing. and you're going to get an hourly charge for the technician's time to interact, or anytime they're doing something with the computer, setting stuff up, getting stuff processing, but you're not charged for processing time, and you're also not charged for hosting. And so, we've had, several big cases over the last few years. You can see, on the left-hand side, the first one is 235 gigabytes of collected data that was processed, 336, and then, really 1.8 terabytes of data. These are, large cases that we had, and we actually went out. We always, from time to time, see what vendor pricing is. We took 3 different vendors to give us quotes, and then we averaged them up here, because even the vendors themselves, vary greatly within their pricing. But those were the average costs the vendors would have charged for what we did in-house. And you can see the second column, what we charged. And once again, they save a lot on e-discovery processing, but they save an enormous amount on hosting. We don't charge to have the data sitting on our network for the attorneys to review or for our clients to remote in and get access to it. We like to look at the savings. That stuff you don't need for us to crunch the data. You use that on the legal side, with the attorneys, for your case itself.
A lot of people have asked us why we have this model, and partners will even say, well, it sounds like we could make more money if we kind of switch to a different model. And for us, what it does is it allows us to put more of your resources at resolving your case on the merits instead of based on e-discovery. That to us will leave you with a happier result. Very few people leave litigation thinking that that's something that they want to do again. That's the reality of being a litigator. But if you're able to leave the litigation feeling like you got the best result possible, and as David mentioned earlier, our mindset when we go into it is we kind of prepare for every case as if it's going to trial. We're not immune to the fact that in the Northern District of Illinois, 98.4% of civil cases still settle. But in our experience, if we approach it with the idea that we're preparing for trial, whether you're a defendant or a plaintiff, you're going to get a better result, whether that means more money into your pocket as a plaintiff or paying out less money as a defendant as you present yourself as being fully prepared for trial. This model really hit home at one of the first cases that we used our internal lab for. In 2006, the Federal Rules of Civil Procedure were amended to include the need to focus on e-discovery. At that point in time, we've always kind of viewed ourselves as a more entrepreneurial law firm than a lot of our competitors, and we decided that we would form our own in-house lab. Part of the reasoning was we had went out, and at that point in time, if you kind of roll back your memory banks, every Photoshop or photocopy vendor that was out there, every copy shop, was turning into an e-discovery vendor even though they had no skills. We took a different path. We went out and we found Mike, and we latched onto him as soon as we could. We hired him in May of 2006, and at that time we were in the process of litigating a large earn-out case. Some of our clients had sold one of their companies to a large public utility out west, and through the earn-out agreement, they were entitled to a potential additional pot of about $25 million in earn-out consideration over the 3 years following the transaction. The earn-out agreement, like most earn-out agreements, required the buyer to maintain data related to the earn-out entity that they would have to provide to the seller so the seller could see, hey, how is the actual earn-out entity performing? And am I entitled to more earn-out compensation? Here, the first step that we undertook in discovery was right before Mike was hired. We took a Rule 30b-6 deposition of the buyer's IT representative to figure out how do they store their data, where is it, what custodian should we focus on, who was really involved here. And like I said, it was a large public utility out west. It was basically the ComEd of the Rockies, so they had multiple locations, multiple servers. During her deposition, which by accident we had videotaped, and Freeborn and I showed up in this cold conference room in Rapid City, South Dakota in the middle of February, and we see this videographer and we thought, why the hell are you here? This is one of the world's most boring depositions that's about to take place. And we didn't have the heart to tell the guy he had to drive all the way halfway across South Dakota. Instead, we decided, all right, roll the tape, let's see what we get. Well, it was a great mistake by my assistant to hire the videographer because the IT director admitted during the deposition that they had decided to make one of these legacy shifts. They had a backup tape system in one of the cities, and they decided to upgrade it. And they used that opportunity while litigation was anticipated to shred about 1,000 backup tapes. And she was quite proud about how they went out and did it. She regaled us with the fact that they hired a group of mentally disabled individuals so that they provided them gainful employment. And at this point, her lawyer's chin is on the ground Freeborn is at the end of the conference table waking up and smiling like, a kid on Christmas morning. And I'm just amazed that she's taking this approach. And she says, well, we wanted to make sure that nobody ever saw this data, so we actually cut the tape every 5 inches. And then I said, what'd you do next? And she said, after that, we burned it. And I said, well, why did you cut it every 5 inches and then just burn it? Why wouldn't you just burn it? And she said, because we didn't want to take any chances. And that became the rallying cry in that case. We came back, and this was right as we were interviewing Mike, but we hadn't yet settled on a deal with him, and we filed an emergency motion. The case was pending here before Judge Kennelly, and we said we want an order that suspends any destruction of any data by this company. They had a contractual obligation to save it and provide it to us. They had a statutory obligation because they were a public utility, and there was no doubt that litigation was anticipated during the time that they committed what we referred to as Shredapalooza. The court considered the motion, and just like we saw in one of the earlier cases, the buyer strode into court very arrogantly and said, Judge, what Freeborn and Peters is asking for is insane. It's going to take 3 years, or I'm sorry, 1.5 years and $3 million to do what they want. That was Mike's first day of work here. He said it was May 30th, 2016. Or 2006. That's a good memory. And we took him along with us to court. And he said, well, what do you want me to do? And we said, well, we know the volume of the data. We want you to tell how much it's going to cost and how long it would take you in this newfangled lab that we just created for you to do it. And so Mike crunches his numbers, and he says, is the judge going to swear me in? We said, we don't know. We'll find out. Just stay tuned. So Judge Kennelly asked Mike he didn't ask him to take the stand, but he asked some questions, and Mike said, we can do it internally in 2 months, 60 days, for $80,000. And the other side was incredulous. And they continued their mantra that this was just overkill and there was no way that we were entitled to this, and nothing relevant had been destroyed. About 30 minutes later, the judge ruled all of their raw data had to be turned over to Mike within 2 days. There was a privilege filter that was put in place because he's our employee, so that we couldn't review any privileged data between their outside counsel and internal counsel. But Freeborn and Peters was the repository for this public utilities raw data for the remainder of the case. The general counsel that flew in from Denver for the case for our opponent, the look on his face when he walked out of that courtroom with the news that he had to go call his CEO and say, there's been a dramatically bad development, it was great. It was a great moment. Eventually, we ran into the problem that you run into in any spoliation case. What you're looking for has been destroyed, but you have to prove what was destroyed, what was relevant to the case. Well, how do you do that? If they truly destroyed it, it's gone. How do you prove what it was? Well, one late night, it was the night before our expert report was due, Mike and I were in the lab along with our outside expert, and a few Freeborn attorneys that I see in the back might have been with us, and Mike had a genius moment like he often does. It was an earn-out case, so a lot of the data that we were seeing were spreadsheets, projections, capitalization tables, expense issues. And so what we noticed in their spreadsheets was certain of the spreadsheets would call out and look for another spreadsheet file. It would have reference not found. And Mike was able to track that file name and then search the entire database for that file name. And when that file name didn't exist, we thought we had proof that we had a relevant spreadsheet that was incomplete because it was looking from data from another file that had been destroyed. And so we went to Judge Kennelly with that, and he agreed that he would probably issue adverse inference instruction once we went to trial. With that, we had a mediation. Judge Kennelly, I don't know how many of you appeared before him, but he doesn't work with a magistrate. He does his own mediations, usually the day before trial, which is a little bit intimidating. And we were $23 million apart at the end of the mediation at lunchtime, and everyone walked away dejected, and Freeborn was drafting an opening argument. Then that weekend, the judge sent us an email, and he said, I'm going to issue a mediator's number, and you have to respond yay or nay. If you accept it, say yes. If not, what would you accept? And the other side agreed. The number was about 95% of the settlement value of the case, and it was the same number in our decision tree analysis that we had submitted to the court, which was primarily based upon Mike's work. So not only have I seen this save clients money just in terms of the cost of gathering, identifying, collecting, processing, and producing the data, but I've seen it have tangible results that I don't think would have occurred if we had used any other vendor. I think it's one of the many examples that we've found where this helps us go back to our clients and say we've delivered value to, and it's more than just a reduced expenditure.
So, what can you do? Obviously, now you're in litigation. Now you have to collect the data and you'll review it. We're collecting it. The biggest thing is making sure it's defensible. We've been able to successfully understand how that our opposition collected documents based on reviewing it and how they produce it to us, and we're able to figure out that they didn't collect it properly. They didn't use the right tools, they were missing stuff, and you go back to the courts and force them to redo their collection and also their document review. Not something you want to happen to you. So it's important that, especially IT folks, clients will say, hey, our IT guys can search our email, we'll take care of that. Well, you have to understand, the technology. Typically Exchange servers, especially, a few years ago, they didn't index attachments, so they weren't searchable. So your IT guys can say, hey, we found the documents, here they are, but they didn't search across attachments. That's not going to hold up. Even if you can search across attachments, what about image-based files that are attachments? You got PDFs. A lot of PDFs out there have no searchable text. You search across it, you have your IT folks do it, you're not going to pull up anything. You're going to miss a lot of documents that are potentially responsive. Archive or container files, you got zip files. Can you dig into those zip files and zip files within zip files? Can your tool get into those? Typically, your IT person's not going to have any idea because this is not what they do. Password protected files. Search across your Exchange server, it's going to skip those. Not even going to see them. So what do you need to do? So you need to understand the technology, and it's important that even if you're going to have your folks do the collection, especially from email, they do it under our guidance, because we can make sure that we account for all these and get those documents and not worry about having to go redo it under very tight time frames. The other thing is, limitations of your collection tools. You need to know what they can and can't do. Using a collection tool, what does it do with all those exceptions? Does it include them or exclude them? Well, you don't want them excluded, because if you can't see them, can't search them, you automatically have to bring those into your document collection. But we have tools that if it can't read it, it brings those in automatically as files as if they hit a search term hit. Destruction of metadata. If you use Windows to copy documents off your network to an external storage device, well, you're destroying some of the file system metadata. Is it important in your case? It may be, it may not be, but you need to understand that, that's happening. Collection log. Once again, if you collect stuff off your computer, give it to an external hard drive, how do we know that file on that hard drive, when we process it and we produce it and we have it in court, how do we know it's the same file that was on your computer? Well, if you don't use software that actually logs that, and we use a piece of software that every file that we're going to collect, it inventories it. It does a digital fingerprint, which is called an MD5 hash of that file prior to copying it, copies that file over to the external hard drive, does another digital fingerprint, and matches those. So we got a log. We can bring in a court and say the file they're saying they changed it. We can say it's the exact same thing that was on their computer. We can prove that. Well, if you're not using the appropriate tools, you can't do that. Custodian interviews. I kind of talked about that before. Your IT group may say, hey, they're told they can't do this. They have to keep files on the network, so you don't have to worry about it. Well, you go talk to the custodians, and they're like, oh, yeah, I got stuff on my H drive, which is your home directory. I got stuff, sitting over here on an external device. Yeah, I know that we're not supposed to do it, but I can work a lot more efficient when I do that. Because when our server crashes, I can still work. So they think they're actually doing something beneficial, but when it comes down to litigation, it could actually cause problems. So even though you have IT policies in place, you need to talk to every individual, because you'll find documents in all kinds of places. And then litigation holds. Like Todd said, you have to send them out when there's reasonably anticipated, maybe before a complaint even comes in, but you need to explain it to people, because there's individuals out there that have no idea what all that means. They read it and say, okay, and continue doing what they're doing. And here's a case, in regards to litigation holds.
Yeah, before we get to this Zurn case, I'll give you a recent example. We get spoiled because we have the benefit of Mike and his crew upstairs, but it's amazing how many lawyers out there don't understand concepts like metadata. I had an example last week that was a fun one. We have a fraudulent transfer case. We have a judgment against one of our clients, has a judgment against a party, and as we got through post-judgment enforcement, they declare bankruptcy. And the one very valuable asset that we'd love to swoop in and just take and say, judgment satisfied, all of a sudden was magically transferred to their son. It was transferred without evaluation of the company before it was transferred and without any real consideration. Well, that's a strong case. It's strong enough to the point where we said, hey, we'll switch you from an hourly fee to a contingency fee if you want. But then when the discovery came in, it got even better. These idiots on the other side had actually went and produced the agreement by supposedly documenting the transfer. And the first time they produced it to us was a PDF. And a PDF, if you go and scan it upstairs on a scanner, its metadata is going to say it was created today whenever you scanned it. So we went back to them and we said, no, we want the native file. And the district court judge in Kansas said, I don't understand why you want that, but sure, give them the native file. Well, the native file is the Word file. And that metadata will show you the day the actual document was authored. So when you go and the author actually clicked create new document or when they saved it. Well, as a result, that document was created the day after the bankruptcy was filed. But the opposing counsel still doesn't understand what they've turned over to us, because a week later, a third party that supposedly received the document that supposedly the company was transferred to, we had a subpoena to them. Well, they produced it as well. That file came back corrupt. Well, that lawyer was at least smart enough to know what the metadata was, and we figured out through Mike's help, had actually gone back in and tried to monkey with the metadata to show that it was in effect backdated, just like they were doing in the hard copy version. And so now we look at the case and we're kind of just relishing the trial because we don't even think our lead opposing counsel has any concept of what our clients have done. And it's going to be a fantastic cross-examination. But there are a lot of people out there that don't have a good grasp of these concepts. And if they're on your other side, please find a way to take advantage of them, because this stuff is not new. But in the Sloan Valve case versus Zurn, a lot of this stuff was happening as well. Zurn searched over file names, not the actual contents. So let's say you have a file name that says, 2016 business plan, but what you're really looking for is what type of profit was expected of the company that year. Well, if you use the search term profit, it wasn't going to show up. It was just complete ignorance. Some obviously had no idea what they were doing. They did Boolean searches by their outside counsel who used a visual inspection. Well, I'd love to see how that went. That's kind of the old eyeball. I don't know, it looks pretty good from here. A litigation hold was sent, but certain of the people testified they didn't even understand what a litigation hold was. When we send out litigation holds, we have people countersign them. We store those as PDFs in our files. We tickler on our Outlook calendars, just like a court deadline or a briefing schedule or a hearing, when someone from lit support or litigation is going to follow up with those custodians to say, as a reminder, we sent you this litigation hold on blank date. We're hereby reminding you have a duty to continue to preserve any information and not destroy it. These people were just given this file and they said they never even read it. It's kind of the typical when you're in a deposition, you show someone the contract that they've sued on and you say, well, have you ever read this document? Say, no, my lawyers did. I have no idea what it says. As a result, in that case, which is often what we see, the court went back and ordered Zurn to kind of redo everything and try to explain away all the deficiencies. And quite frankly, if you're the lawyer defending Zurn at that point, the horse is out of the barn. What are you going to say? Well, we gave him the litigation hold, but we didn't explain it to him. Well, what confidence then will anyone have that someone actually complied with it if they didn't even understand what the obligations were?
The other thing you take into consideration now, you have the documents. We get a lot of times where we'll put or the client will put a broad preservation in to make sure nothing's destroyed, but then they'll start collecting from 50 individuals. Like, why are we collecting from someone's secretary? Because they may have been copied on an email, and someone that was a very small part of it. So it's important to kind of identify the key custodians. You can always go back and add custodians if you find out that they had a bigger part in the case, because they're still under a litigation hold. But limit the custodians and with the other side on what you're actually going to be collecting from. Time frame, obviously, if you can narrow it down from the collection standpoint, there's a lot less that you're going to process and have to review. File types, if you don't need audio, video files, if you don't need photos, images, and all that, you can really reduce the collection and reduce your cost. And another thing, domain names. You might have your key engineer was working with 5 different law firms. Well, it was only one law firm that was involved, in this case. You might have the same key terms are going to come across, everything he was doing. Well, you can limit anything with freeborn.com. All that stuff is gone. So there's a lot of ways that you can really cool down and be creative and limit what the attorneys are actually going to see.
And when you do that, try to get your outside counsel, or if you're doing it directly, get your other side's agreement and document that in the case management order or something. Don't just do it on your own and then hope that they're going to be reasonable down the road, because inevitably something's going to come up in a deposition where all of a sudden a new key custodian's identified. Somebody forgot that Sally or Bob left the company 3 years ago, but they actually were the one that were, the key person on the project. And then you don't want to be heard about the fact that Bob or Sally's data was spoliated because they left the company so long ago. Try to get them to countersign off on it. And if hopefully you can get to the point, what we enjoy doing is actually getting to the point where the pre-production data is here early enough for the attorneys to begin to do iterative searching on it. See what different search terms turn up. See what that, it's just like a Westlaw search. You type something in and you get 5,000 cases. Okay, well, that's the wrong search. Figure out what's reasonable and what terms are triggering what documents, and see if there's a way that you can strategically propose something to the other side. Nobody is going to think that anyone is going to review every document in every case. But if you can just, craft your search terms carefully enough to return a reasonable number of documents, and maybe some documents and not others, you can get a real benefit in the litigation substantively.
We're on the last slide, and we're given Q&A. This is just using technology and how you can reduce your set and be more efficient in it, but using concept search and how to group the data prior to review. And if you do that, one attorney's going through the same set of data, similar concepts all at once, instead of over the course of 3-4 weeks. 3 different attorneys are seeing parts of that data set. You group it, have one person go through it. You're 10 times more efficient. You're going through it all at once. You're going to have a faster review, more efficient, and a much better review.
Thanks for attending. Thanks for your attention and time and energy, and we look forward to hopefully seeing you all at the game. Go Cardinals.